Here is something most homeowners don't know, and the ones who do know it have usually learned the hard way, sitting at a kitchen table staring at a document they never expected to receive. In 41 states in this country, including my state of Westmere, a homeowners association has the legal authority to file a lien against your property for unpaid dues. Most people know that part. What most people don't know is what the statute says after that. Under the Westmere Residential Property Act, Section 47C, if a homeowner fails to satisfy a recorded HOA lien within 60 days of filing, the association, or its authorized management agent, may initiate non-judicial foreclosure proceedings. Not a bank, not a mortgage company with 6 figures of debt attached to your name. A homeowners association, for any dollar amount. The law specifies no minimum threshold. I have read that statute multiple times. I have read it at 2 in the morning, sitting at my desk, and I have read it in the waiting rooms of 2 different attorneys' offices, and every time it says exactly the same thing. What I'm going to tell you today is the story of a company that understood that statute the way a surgeon understands an anatomy chart, completely, precisely, and with a clear sense of which point of pressure produces the most damage. I'm going to tell you what they built, how they operated across 14 communities in a single county, how much they took, and how everything they had constructed came apart over the course of 13 months. I'm also going to tell you who I am, because in this story, my identity is not background detail. It is the mechanism by which everything else became possible. My name, for the purposes of this account, is Diana Mercer. I am 41 years old. I have 2 daughters, Kayla, who was 19 at the start of this story, and in her second semester at Delmore State University, and Mia, who was 13 and halfway through 8th grade. I bought our home in the Creekside Commons subdivision of Crestwood Falls, Westmere, in March of 2022. The purchase price was $412,000. 4 bedrooms, a detached garage, mature trees in the backyard, and enough driveway space that Mia could practice her free throws without the ball rolling into the street. It was the first property I had ever purchased entirely on my own. I had finalized my divorce 8 months before the closing. I was starting over at 40, I in a city I had lived in my whole life but had never fully claimed as mine. That house was mine. And I want to be direct from the outset. I bought it with money I had earned. That matters to the story. What also matters to the story is my father. Raymond Mercer founded Harwick Savings and Trust in 1981. He was 33 years old, and he had $340,000 in seed capital, a lease on a storefront at 114 Garfield Avenue in Crestwood Falls, and the particular kind of stubbornness that either builds something lasting or destroys a person in the attempt. In his case, it built something lasting. By the time he retired in 2016, Harwick had grown to 11 branches across 4 counties, a residential loan portfolio exceeding $900 million, and approximately $1.4 billion in total assets. He was known in Delmore County the way certain people are known in small regions. Not famous exactly, but structurally present. His name was on 2 buildings, a scholarship endowment at Delmore State, and the dedication plaques in the lobby of every branch he opened. He passed away in October of 2020. He left me 62% of the voting shares in Harwick Savings and Trust. My brother Nathan holds 34%. The remaining 4% was distributed to long-serving employees over the years as stock grants. I did not advertise this. I want to be precise about that word, advertise. I made a deliberate and considered decision not to lead with it. I spent 20 years of my career as a bank compliance officer, reviewing financial structures for regulatory soundness. identifying control failures, preparing institutions for examination. That career, and watching my father navigate his version of it before me, had taught me something consistent about money and relationships. When people know you have significant assets, every subsequent interaction is filtered through that knowledge. What you offer as a person gets processed first through what you represent as a resource. So when I moved to Creekside Commons in March of 2022, I introduced myself as Diana Mercer, financial consultant. Which is also true. I run a consulting practice with 7 small business clients. I keep regular hours, send invoices, pay taxes on that income. I simply did not mention the bank. I had no reason to believe I would ever need to. I want to sit with that for a moment, because I've thought about it many times since. The decisions we make about how to present ourselves in a new place, the things we choose to show, and the things we keep private, carry consequences we cannot predict. Sometimes one of those consequences is that the people who decide to make you a target have no idea who they're choosing. Creekside Commons was developed between 1997 and 2004. At full build-out, 412 single-family homes, a community pool that closed every Labor Day regardless of weather, 2 pocket parks that saw minimal use, and a homeowners association that had been resident-governed since its founding. That changed in 2018. The resident board, citing volunteer burnout, increasing operational complexity, and a desire for professional management, voted to engage an outside management company. The company they selected was Hartwell Property Solutions, LLC, headquartered in Varennes, Westmere, approximately 40 minutes west of Crestwood Falls. Under the contract, I eventually obtained through a formal records request, filed under the Westmere Homeowners Association Transparency Act, Statute Section 29-604. Hartwell assumed full management responsibility, dues collection, reserve fund administration, contractor procurement, vendor oversight, financial reporting, and compliance enforcement. In exchange, they received a management fee of $14,200 per month. The resident board did not dissolve. It was reduced to 3 members who received quarterly summary reports from Hartwell and retained nominal authority over major decisions. In practice, as I would come to understand, they signed what Hartwell presented and approved what Hartwell recommended. Whether this represented coercion, in willful blindness, or simple exhaustion, I have thought about a great deal. I have landed on a position, but that comes later. The man who served as Hartwell's regional director for Creekside Commons was named Paul Griffin. He was in his mid-50s, methodical and professional in his communications, and possessed of the specific institutional confidence of someone who has operated without meaningful accountability for a long time. I attended one board meeting after moving in, September 2022, and I watched him deliver Hartwell's quarterly summary with the flat authority of a man who understood that the room would not push back. The 3 board members did not ask questions. The handful of homeowners who attended raised concerns about landscaping. I noted what I had observed. I went home to my daughters. I did not yet know that Hartwell managed not one HOA in Delmore County, but 14. I did not know what they had been doing across those 14 communities for 4 years. I found all of that out later, but the September 2022 meeting stayed with me as a data point, the kind of small observation that means nothing on its own and means everything in retrospect. The letter from Hartwell arrived on September 14, 2023. It was formatted precisely. Official letterhead, reference numbers, a paragraph block written with the dense professional neutrality of a document designed to discourage close reading. It informed me that I carried an outstanding balance of $4,217.50 in unpaid special assessment fees. The assessment was described as a roof repair reserve contribution, levied across all 412 homeowners in April 2023. The letter stated that this balance had been delinquent for 156 days. It cited Section 47(c) of the Westmere Residential Property Act and stated that if the balance was not paid within 30 days, Hartwell Property Solutions, acting as authorized agent for Creekside Commons HOA, would proceed with formal lien filing against my property. I read it 3 times. Then I went to my filing cabinet. I had paid that assessment. I paid it on March 7, 2023. Personal check number 2241, payable to Creekside Commons HOA in the amount of $3,800, the exact figure specified in the original assessment notice. The check cleared on March 10th. I had the canceled check image. I had the bank statement. I had the receipt confirmation from Hartwell's homeowner portal. Timestamp 11:47 a.m., March 7th. Confirmation number HPS-CC-22413. The documentation was complete. Under any ordinary interpretation of circumstances, this should have resolved with one phone call and a copy-paste of the confirmation number. I have been there professionally. Billing disputes with solid documentation are administrative noise. Oh, you produce the evidence, the system corrects itself, everyone moves on. I scheduled a call with Hartwell's billing department for September 18th. I prepared my file. And then, on the evening of September 16th, sitting at the kitchen table while Mia finished her homework, I went back to the original April assessment notice. The amount specified was $3,800. I had paid $3,800, but the demand letter claimed I owed $4,217.50. That was a discrepancy of $417.50. And that $417.50 appeared without any line item explanation. No notation of late fees, no reference to interest or penalties, no additional assessment, just a number that did not correspond to anything in writing. If you've ever stared at a figure in an official document that simply does not match, not obviously wrong, just quietly wrong, in a way that requires you to actually stop and check, you know what that specific kind of stillness feels like. It's not panic. It's the moment where a competent person recognizes that something has been designed to slide past them and decides that it won't. I canceled the call. I sat down and drafted a formal records request instead. The request was filed under Section 29-604 of the Westmere Homeowners Association Transparency Act. I requested the complete financial records of Creekside Commons HOA for January 2019 through September 2023, audited financial statements, full reserve fund account records with transaction-level detail, all contractor invoices exceeding $5,000, complete vendor contracts, board meeting minutes, and the unredacted management agreement with Hartwell Property Solutions. They had 15 business days to respond. On day 14, Hartwell sent 47 pages. I read all 47 in one sitting with a highlighter. What they sent me was a carefully designed approximation of financial documentation. Reserve fund balances stated as single figures with no transaction ledger. Contractor expenditures organized by category. Grounds maintenance, structural repairs, common area improvements, without vendor identification, invoice numbers or payment dates, HOA income statements showing dues as aggregate annual totals with no monthly breakdown, board meeting minutes that were 3 to 4 sentences each, recording motions and votes without substantive discussion. It was the financial equivalent of a painted backdrop. It had the visual dimensions of documentation without any of the internal structure. I called Renata Hollis. Renata and I had worked together 12 years earlier when she was a senior examiner with the Westmere State Banking Commission, and I was a compliance officer at a mid-sized commercial lender. She had left the commission in 2016 and gone independent as a forensic accountant. She was the most methodical professional I had ever worked alongside, and she had the specific quality of never being surprised by what she found, only by how long it had been permitted to continue. I paid her $8,500 for a 30-day engagement. I gave her the Hartwell documents, my own payment records, and comparable HOA financial filings I had obtained from the Delmore County Recorder's Office for communities of similar size and age. I also gave her a handwritten note describing the specific questions I could not yet answer. Renata has always preferred to know what the client already suspects. She called me on a Tuesday evening in late October. "Diana," she said, "I need you to come in tomorrow." I'll describe what Renata's analysis produced in plain language, because the specifics are not background. They are the story. Finding 1, the Reserve Fund. As of January 2023, based on Creekside Commons' own stated contribution rates across the preceding 5 years, the Reserve Fund should have held approximately $1.1 million. The account held $203,000. The difference, $897,000, could not be accounted for in any of the documentation Hartwell had provided. No expenditure records, no transfer authorizations, no corresponding invoices. The money had moved, and the movement had been deliberately obscured. Finding 2, the vendor. Between 2019 and 2023, Hartwell had directed 11 maintenance and repair contracts to a company called Pinnacle Grounds and Facilities, LLC. Total invoiced value, $847,000. When Renata ran a standard business entity search through the Westmere Secretary of State's database, Pinnacle Grounds and Facilities, LLC, appeared as a domestic limited liability company registered in March of 2019, 4 months after Hartwell assumed management of Creekside Commons. The registered agent address was a commercial mailbox service on Clover Street in Varennes. The sole listed member of the operating agreement was a woman named Cynthia Griffin, Paul Griffin's wife. Hartwell's regional director had been awarding community maintenance contracts funded by resident dues to a company owned by his wife since the month he took over management. He had done this without disclosing the relationship to the board. He had done it across 4 years, $847,000 in invoices, in a single community, while submitting financial summaries that described these payments only as contractor expenditures, with no vendor identification. Finding 3, the liens. Renata cross-referenced county lien records against a homeowner address database she had assembled from public property records. In the 18 months preceding my September letter, 47 homeowners in Creekside Commons had received demand letters from Hartwell for amounts that did not correspond to any recorded assessment. Of those 47, 11 had paid the disputed amount without question. 12 had received the lien notice and paid after the lien was filed. 7 had sold their homes. Of those 7 properties, 5 had been purchased within 90 days of the sale by a limited liability company called Delmore Residential Partners, at prices ranging from 8 to 14% below the Delmore County average for comparable homes in the same subdivision. Delmore Residential Partners was registered in Westmere in January 2019. Its registered agent address was the same commercial mailbox on Clover Street in Varennes. The managing member listed on the operating agreement, Paul Griffin. I've told this part of the story a number of times now, And people always expect me to describe what I felt in that moment as rage. But it wasn't rage. It was the particular exhaustion that comes with confirming something you had already understood at an outline level. The exhaustion of watching a shape fill in completely. What Renata had done was put the detail inside a frame that had been there from the beginning. And that is the moment I stopped being a homeowner with a billing dispute and became a person with a much larger problem to solve. Renata estimated total misappropriation at Creekside Commons alone, $1.3 million over 4 years. Then she turned to the last page of her report. Hartwell Property Solutions, she had determined through public filings and comparative financial analysis, managed not one HOA in Delmore County. It managed 14. I need to explain something about the Harwick Savings and Trust, and about the decision I made carefully and with specific intention. Harwick held active residential mortgage accounts on 340 of the 412 homes in Creekside Commons. This was not unusual. Harwick had been the primary mortgage institution for Delmore County's residential developments since the late 1980s, and Creekside Commons had been built squarely within its established lending geography. Those 340 mortgages represented approximately $94 million in outstanding principal. Harwick also held the operating bank accounts for 11 of the 14 HOA communities that Hartwell managed. The Creekside Commons HOA maintained its primary operating account, its reserve fund account, and its special assessment collection account at Harwick's Crestwood Falls branch on Meridian Road. I need to be precise about the line I drew here because it mattered then, and it matters to me now. I am a 62% controlling shareholder of Harwick Savings and Trust, but I do not run the bank's daily operations. Harwick has a CEO, a man named Gerald Tate, who has managed the bank's executive functions since 2017. I serve on the board of directors. I have significant governance influence. But from the first moment I identified what Hartwell had done, I was scrupulous that I would not use the bank's operational capacity as a private instrument. That would not be legal, it would not be ethical, and more practically, it would have helped one homeowner. Me. Every other family in those 14 communities would have received nothing. What I did use was legitimate board governance. As a director, I requested a compliance review of all HOA-associated accounts held in Harwick's portfolio, a standard concentration risk exercise within the board's established authority. Gerald authorized it the same day I made the request. He did not ask why. The review took 3 weeks. Its results confirmed and extended everything Renata had found. Across all 11 HOA accounts held at Harwick, reserve fund balances were in almost every case dramatically lower than contribution inflows should have supported. In 3 communities, reserve fund accounts had been drawn to near zero over periods of 12 to 18 months. Transaction records showed systematic transfers routed through Pinnacle Grounds and Facilities, and 2 additional vendor entities, Meridian Site Services and Blue Ridge Facilities Group, that had never appeared in any financial summary distributed to homeowners. Renata's estimate for Creekside Commons was confirmed. The estimated total misappropriation across all 14 communities, based on Harwick's account transaction data, $2.3 million. I printed the compliance review summary, placed it in a manila folder beside Renata's 94-page forensic report, and called the Westmere Attorney General's Consumer Protection Division. The investigator assigned was named Marcus Webb. He had the patient, measured manner of someone who had spent years receiving information from people who were either exaggerating or incorrect, and had developed careful professional neutrality as a result. He took my initial summary call, asked me to send the documentation, and told me he would follow up within 2 weeks. He called me back in 11 days. "Ms. Mercer," he said, I need you to help me understand how a financial consultant in Crestwood Falls ended up with a 94-page forensic accounting report on an HOA management company and a bank compliance review covering 11 HOA accounts across Delmore County. I told him who I was, the bank, my father, the shares, and the governance request, and precisely why it was legitimate. He was quiet for a moment. Then, "And you didn't use the bank to act against them directly?" "No," I said. Another pause. "Why not?" "Because it would have helped one homeowner." "Me." He asked me to come in. The speed of what followed surprised me, and I believe that speed had two sources. First, the completeness of what I delivered. The AG's office did not need to build the case from the ground up. Renata and I had assembled it. They needed to verify and formalize. Second, the scale. 14 communities, thousands of families, $2.3 million in documented misappropriation. A property acquisition scheme built on manufactured liens designed to push homeowners out and buy their homes below market value through an affiliated LLC. This was not a civil nuisance. It had criminal dimensions that both the AG's Consumer Protection Division and the Delmore County District Attorney's Office recognized immediately. On November 4, 2023, simultaneous search warrants were executed at Hartwell Property Solutions offices in Varennes and at the registered addresses of Pinnacle Grounds and Facilities, Delmore Residential Partners, Meridian Site Services, and Blue Ridge Facilities Group. I was at home. Mia was doing homework at the kitchen table. I said nothing. 2 days later, my phone rang. Unrecognized number. I almost didn't answer it. It was Paul Griffin. He had a contact at the Delmore County Civil Records Office who had flagged my October transparency request as potentially related to the investigation timeline. It was a loose thread. Paul Griffin was the kind of man who pulled loose threads, which is, in retrospect, a notable quality in someone whose entire operation was composed of almost nothing else. He did not introduce himself. He said, "I know you're the one who went to the AG." I said, "Then you know what I found." He moved immediately to negotiation. He would return the misappropriated funds to the reserve accounts. He would withdraw all pending liens, including mine. He would restructure Hartwell's management contracts across all 14 communities. He was prepared to engage a mediator on a settlement framework. He wanted a number. I thought about the 11 families who had paid without question, the 12 who had paid after the lien was filed, the 7 who had sold their homes, the 3 communities whose reserve funds had been reduced to nearly zero, while families continued paying dues in good faith, believing that money was being saved on their behalf. "Paul," I said, "the AG's office has your records. The bank has your complete transaction history. 47 homeowners in this community alone have documentation of your lien filings. This is not a negotiation. There is no number." He hung up. I sat at my desk for a long moment. Then I called Gerald Tate and instructed him to implement a compliance hold on all Hartwell-associated HOA accounts under Harwick's custody, pending the active governmental investigation. This was entirely routine under federal banking regulations and the Westmere Financial Institutions Act, Section 112. Accounts under active governmental investigation are subject to administrative holds as a standard consumer protection measure. It required no extraordinary authority. It required only the right circumstances and someone who was paying attention. Hartwell Property Solutions lost access to $890,000 in HOA reserve fund balances that afternoon. The Westmere Attorney General filed civil enforcement action on December 2, 2023. Named defendants, Hartwell Property Solutions, LLC, Pinnacle Grounds and Facilities, LLC, Delmore Residential Partners, LLC, Meridian Site Services, Blue Ridge Facilities Group, Paul Griffin individually, and Cynthia Griffin individually. The action alleged violations of the Westmere Consumer Protection Act, Sections 8-901 through 8-917, covering deceptive business practices in residential property management. Violations of the Westmere HOA Fiduciary Accountability Act and common law fraud and breach of fiduciary duty. The Delmore County District Attorney opened a parallel criminal investigation 3 days later. By mid-January, evidence had been presented to a grand jury. On January 19, 2024, an indictment was returned charging Paul Griffin with 31 counts: theft by deception, criminal conspiracy, money laundering, and fraudulent conveyance, the last charge relating specifically to the Delmore Residential Partners property acquisitions. Bail was set at $750,000. A court-ordered receivership over Hartwell's management operations was implemented in February 2024. A court-appointed receiver assumed administrative control of all 14 communities. The Harwick compliance hold was formally integrated into the receivership order, with the $890,000 in frozen account balances preserved as restitution assets. The forensic reconstruction of reserve fund accounts across all 14 communities took 4 months under receiver supervision. The final confirmed misappropriation figure, $2,417,000. All 47 fraudulent lien filings in Creekside Commons were vacated by court order. The 16 properties acquired by Delmore Residential Partners through the fraudulent lien process were ordered returned to their original sellers at original purchase price plus a 6% interest supplement under the Westmere Fraudulent Conveyance Statute, Section 44-210. My lien was formally vacated on February 14, 2024. Mia pointed out that it was Valentine's Day and announced that the HOA got dumped, which remains the most accurate summary of the situation I have heard from any source. The criminal proceedings against Paul Griffin are, as of the time I'm recording this, still pending trial. That process takes time. The civil enforcement action has produced agreed orders requiring full restitution. The money is going back, not every dollar, because some of it moved through structures designed to make recovery difficult, but the frozen assets, the disgorged property flip proceeds, the Harwick held reserve balances. 2,000 families across 14 communities in Delmore County have their reserve funds restored and their management returned to court-supervised administration. I told you at the beginning that this story has a cost. I meant it, and I want to be honest about what that means. When the AG's civil filing became public record in December, a local news outlet matched my name in the cooperating witness documentation with Harwick Savings and Trust. They published a story the following week. The headline read, "Banker's Daughter Exposes HOA Fraud Scheme Using Family Bank." It was accurate. It was also reductive in the way that headlines often are, which is to say it was accurate about the facts and entirely missing the context, and the combination of those two things can cause its own kind of damage. Kayla read it on her phone at university. She called me that evening. I had not hidden the existence of Harwick from my daughters. I had told them, as they grew old enough to understand, that our family had a financial interest in the bank their grandfather built. I told them we were secure, that their grandfather had been a careful and generous man. What I had not told them, what I had kept deliberately vague, was the scale, the 62%, what $1.4 billion in total assets means in concrete terms about how a family occupies the world. Kayla was not angry in the way that produces raised voices. She was angry in the quieter way, which is the kind that stays and requires actual conversation to move through. She said, "Mom, I've been on a financial aid package for 2 semesters. I didn't need to be." She was not wrong. My reasons, privacy, protection, the desire for my daughters to build identities around something other than inherited wealth. Those reasons are real, and I still believe they were good ones. But a good reason for a decision that affects another person is not the same thing as that person's consent to the decision. I had made a unilateral choice about information that was also hers. And when the world made that choice visible in a news headline before I did, I lost the ability to deliver it on my own terms and on her timeline. We talked through spring break, 2 full days. It moved, but it did not resolve. Mia processed the entire situation differently. She decided that what mattered was that Mom beat the HOA guys, which she announced with unambiguous satisfaction over a bowl of cereal. And I chose to hold on to that as a genuine source of warmth in an otherwise complicated season. I've been around legal and financial systems long enough to know that a story where someone wins everything, cleanly and at no personal cost, is not a story. It's a fantasy built for people who haven't been through the thing they're being comforted about. What makes a real fight real is that you can be methodical and correct and legally sound in every decision you make, and then still find the cost showing up somewhere you weren't watching. Not in a courtroom, at a kitchen table, in the face of someone you love who is looking at you and asking a question you should have answered earlier. That's where I am. Not broken, not defeated, but honest about the whole shape of it. I've thought a great deal about what to take from this story, and I don't think the lesson is know your rights, though you absolutely should. I don't think it's just about keeping your financial documents organized, although that is more important than people realize until they need to prove something that happened 18 months ago. What I keep coming back to is the architecture of what Hartwell built and what made it function. Paul Griffin looked at 412 homes in Creekside Commons and concluded he understood exactly what those homeowners would do when a letter arrived on official letterhead citing a legal statute and specifying a dollar amount. He had refined that calculation across 14 communities over 4 years. He knew the percentage who would pay immediately. He knew the percentage who would negotiate and settle for half. He knew the percentage who would sell rather than fight. It was, in a deeply perverted sense, sophisticated actuarial modeling. He was right about most of those homeowners. He was wrong about one. And what I want you to carry from this, not as a lesson about bank ownership, because most people don't have a bank and that is not the point, is that these schemes, the management companies and the shell vendors and the manufactured liens and the fraudulent demand letters, they are built on one foundational assumption, that you will not look closely, that the institutional packaging, the legal language, the official letterhead, will produce in you either immediate compliance or paralyzing uncertainty. The moment you pull the thread, the moment you make the records request the transaction ledger, cross-reference the vendor registration, put the numbers in a column and ask where the difference went, you have already broken the assumption the entire structure depends on. And without that assumption, these operations are considerably more fragile than they appear. If this story made you think about the HOA financial summaries you've received and filed without reading, the demand letters you've questioned and then paid to make the discomfort stop, the management companies operating in your community with no meaningful accountability, share it with someone who needs to hear it, not as a generic ask. The people who need these stories are in every planned community in America, and most of them have never been told how the system actually works. And if you've been there yourself, if you've received the letter, faced the lien, wondered whether you had any ground to stand on, tell me in the comments. I read all of them. This is HOA Nightmares. I'll see you in the next one.